Good afternoon. This is Kristen O'Neill with the New York State Committee on Open Government. Today we will be going over the basics and updates to the New York State Freedom of Information Law. I'm going to put some helpful information in the chat feature in case people were not able to see it earlier. The first thing I'm entering in is our website. See, you got our website up there. And the second thing I'm going to enter in is the specific portion of our website that contains a link to our training materials and recordings. So when this program is done, it is being recorded. It will get uploaded hopefully no later than the middle of next week, hopefully even by the end of this week, to our website. Copies of the PowerPoint that you're looking at now. PDF copy of the PowerPoint will be available on that same page. So it's opengovernment.ny.gov, and then there's a section on our page that leads you to training materials and recordings. So today we're going to talk about the New York State Freedom of Information Law. Up on the screen right now, you'll see my contact information. There's our office telephone number for those of you that are not aware that we are a pretty tiny office in terms of for government standards. We have our executive director, myself, a senior attorney who's currently out on family leave. Very much looking forward to having her back at the end of October, beginning of November. And we have a brand new Excelsior fellow who will be here with us for 2 years. But he only just started a couple weeks ago, so he's catching up very quickly, but it'll be a little bit of a learning curve. So right now, if people do have questions regarding FOIL or the Open Meetings Law, if I take a little bit longer to get back to you than we normally would, please forgive us. It's just the short staff aspect of our office. There's our phone number, it's our website. At the end of the program, the last slide will include a copy of our office email address, but that's COOG, our acronym is COOG, C-O-O-G, at dos.ny.gov, but it is at the end of the slideshow, and it's also available on our website. So the Freedom of Information Law is codified in Public Officers Law, Article 6. Copy of that statute is available right on our website. So this is what our website looks like. At the top of the screen in this sort of greenish blue bar, you'll see the headings. Each of these headings brings you to a drop-down menu that links to the statute for the Freedom of Information Law. It also links to our regulations, which have the force and effect of law, our advisory opinions, case law summaries. Same goes for the Open Meetings Law. This link will tell you when any upcoming meetings or events are going to occur, anything that's happened recently with regard to updates to the Open Meetings Law or the Freedom of Information Law. That's going to be available here under News. There's a Contact Us page if you'd like to call us or email us. On this big sort of open space currently right now on our website, we have a post that we have an upcoming meeting of the Committee on Open Government, which people are welcome to attend in person or via WebEx. That information is available right on our homepage. So if people are interested, someone mentioned that they're not getting video. I don't know if people want to note in caps, is this a universal problem or is it maybe just a one-person problem? Does anyone mind weighing in to see if they are getting video or are not getting video? I don't have my I have another person saying, has the webcast started? So that's not a good sign. All right, I just turned my video on, but I'm not sure why people are not able to see the screen. I'm getting a couple of people telling me that that they're not able to see anything. So I haven't seen anyone weigh in saying that they are able to see anything, so I'm not sure what's going on. Let me play around with this, see if there's anything I'm missing here. Can people hear me and not just see video, or is it that they're not getting anything? If I don't get a response back, I'll assume you can't hear me either. Can people see and hear me now? Sorry about that, everyone. I'm not sure what the problem was, but hopefully we can get going. Oh, had not quite this much of a problem this morning when I was doing the OML. They must have made some updates to WebEx that I was not aware of. So I think hopefully I'm gonna just stop my video. I'm gonna go to sharing. Well, first I'm gonna share, and let's make sure that works before we do anything else. Can you see the PowerPoint? Does anyone mind typing in whether they can see the PowerPoint? Wonderful. Sorry about that, everybody, it's for the technical confusion. All right, so hopefully we can start over. Sorry about all the waste of time for you guys waiting for the past few minutes. I've been talking away thinking everybody could hear me. Anyway, so I'll go through this quickly. So Kristen O'Neill with the New York State Committee on Open Government. We're here today to talk about the New York State Freedom of Information Law. I'll just do an overview and an update on what's going on in the world of freedom of information law lately. Luckily, there haven't been too many significant changes in the past year. Anything, it's fairly minor. Up on the screen is our phone number, our website, the last screen has the last slide does have our email address, but it's COOG, which is the acronym for Committee on Open Government, coog@dos.ny.gov. Freedom of Information Law is codified in Public Officers Law Article 6. You can always find a copy of both the Freedom of Information Law and the Open Meetings Law right on our website. These up at that greenish blue bar, those are drop-down menus that have access to our law, the regulations, advisory opinions. There's information about any upcoming meetings or events. There's a contact us page. The main screen usually includes any interesting news that we think people are going to want to know about once we become aware of it. Like right now, for example, we do have a Committee on Open Government meeting next week. That's posted up there. So if people would like to attend in person or via WebEx, there's a link, directions for how to do that. Whenever I'm having these virtual programs, I try to put that up there. But again, like even simple things like amendments to the statute or any interesting case law, those are the types of things that we try to get up on our website so people can be aware. So the original the Freedom of Information Law, sorry, I'm still having technical difficulties apparently, was enacted in 1974. The 1974 version was significantly different from the version that we know and love today. It gave access to 9 categories of records from government agencies, and if the type of record that you were seeking was not encompassed within those 9 categories of records, they were not available under the Freedom of Information Law. It was not a very popular version of the statute, so it was repealed and replaced with what is essentially the current version of the law in 1978. Of course, there's been several amendments since then, but the basic concept remains unchanged, and that in New York state law, Freedom of Information Law is based on a presumption of access. And that means when an agency receives a request for records or Freedom of Information Law request, they should always start with the assumption that all government records are subject to FOIL disclosure. And then they can review them to determine whether the record or any portion of the record fits into one of the permissible grounds for denial. So when I get questions like, oh, is this FOILable? Is this a public record? I always encourage the person who's, especially if I'm talking to somebody who works for the government agency, to sort of reverse that question and assume that the record is subject to FOIL, and then look to see whether any portion of the record or the record its entirety is subject to any of the permissible grounds for denial. Who is covered by FOIL? Governs access to agency records, and the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state for any one or more municipalities thereof. The judiciary is completely exempt from the Freedom of Information Law. Any records maintained by the judiciary, by the courts, access to those records is not governed by the Freedom of Information Law. Doesn't mean that many of those records aren't publicly available. It's just that FOIL is not the appropriate mechanism for obtaining them. The Freedom of Information Law does govern access to certain records of the state legislature, but it's in a way very similar to the original 1974 version of the statute, in that the Freedom of Information Law contains a list of the type of records you can obtain from the state legislature, and if it's not on that list, then it is not available under FOIL. Every agency that is subject to FOIL is required to appoint either a single individual or multiple individuals to serve as agency records access officer. So the governing body or the head of an agency is responsible for ensuring compliance with both the Freedom of Information Law and the corresponding regulations issued by the Committee on Open Government. And every agency is required to designate one or more persons as records access officer by their name or by specific job title. This designation should include a business address and an email address. And that person has the duty of coordinating the agency's response to a public request for access to records. Under the Freedom of Information Law, the term record is defined incredibly broadly. It's any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. The statutory definition includes a non-exhaustive list of examples, but the courts have interpreted the term record very broadly. Something as simple as sending one of your coworkers an invitation to lunch via email becomes a record subject to FOIL. You're sitting in a meeting and start taking notes, you're creating a record subject to FOIL. And I'm not saying that necessarily every record that is created that is subject to FOIL is going to need to be disclosed under FOIL, just that they are records, as that term is defined by the statute. Under the Freedom of Information Law, no agency is required to create a record in order to respond to a Freedom of Information Law request. Does not mean that the agency is not required to make copies of records or to convert the records to a preferred format. It just means that they're not required to manually type up or create some sort of new record that did not exist prior to the request. For example, you're not required to answer questions if you're a government agency. Yes, as government agencies, we answer questions all the time, but that's not something we are required to do because of the Freedom of Information Law. The Freedom of Information Law governs access to existing records and does not require an agency to manually create new records, answer questions, or provide information that does not exist in record form. There are 3 exceptions to this rule. Every agency is required under the Freedom of Information Law to create, maintain, and make available to the public a record of how each member of a public body that is housed by the agency voted on any given matter. The second record is a list of the name, public office address, title, and salary of all of its employees and officials. And the third is a reasonably detailed subject matter list of records maintained by the agency, regardless of whether or not they would be available under the Freedom of Information Law. Many government agencies, for example, at the local level, cities, towns, villages, counties, school districts, many of them adopt the record retention and disposition schedule established by the New York State Archives as their reasonably detailed subject matter list, and that works for us. We think that it satisfies the statutory requirement. At the state agency level, a record retention and disposition schedule is probably a good jumping off point, but is probably not going to be sufficient to fully comply with the requirement, because every state agency does something a little bit different and has different types of records. So to focus a little bit more on the distinction between creating a new record and preparing a copy of an existing records, the law states that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. So what does this mean? For example, if you have records that exist only in paper and the person has requested that you scan them and email them to them, and you have the ability to do that. For example, you have a multi-function copier scanner, and you can scan those records just as easily as you would have photocopied them, then you would be obligated to provide them in the medium that they're requested if you are reasonably able to do so. Another example of where this provision comes into play is when an applicant requests a record in their original format. So sometimes people want records that the agency maintains in Excel, something along those lines, an editable format. and the agency gets a little nervous and doesn't want to really disclose an Excel document. So what they do is they convert it to an uneditable PDF and send it to the person that way. However, if the person who made the request wants that original Excel document, the agency is required to provide the original Excel document. They have the right to receive the record and the medium requested if the agency can reasonably do so. The law also states that when an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. The law also states that any programming necessary to retrieve the record and to transfer that record to the medium requested by a person shall not be deemed to be the preparation or the creation of a new record. So what the legislature intended here is to reflect that the database itself is the record. If you have a database full of all sorts of information, that database is the record. If someone asks for a report that contains certain data elements, and the agency is able to query the database and produce a report that contains those data elements, the law requires that the agency do so, even if that report is not one that it would normally produce in the regular course of business. An applicant, when submitting a request, has an obligation to reasonably describe the record sought. So what does that mean? It means that the person has provided sufficient detail to allow the agency to identify the records that are being sought and to locate those records with reasonable effort. And sometimes the answer to whether an agency can locate or retrieve a record with reasonable effort is going to depend on how the agency maintains its records, what its filing system is like. And also it will probably be very different depending on whether those records are maintained simply in paper or whether they're maintained electronically. For example, the Committee on Open Government, for many years, there's an obligation under FOIL to provide the Committee on Open Government with a copy of all appeals. This is an obligation placed on the agency, not on the applicant. The agency is obligated to provide the Committee on Open Government with copies of all appeals it receives and the ensuing appeal determination. And for many, many years, most of what we received was in paper. And so what would happen is we would open the mail every day. We would review the appeals that came in. If we thought something warranted an intervention of some sort, because it raised super red flags, we would contact the agency. But in general, we would review them and then they would basically get filed in a filing cabinet based on the date they were received. They were not logged. We didn't have any sort of database of the appeals that we received. They were simply placed in a filing cabinet. So if someone had come to us at the Committee on Open Government and made a Freedom of Information Law request for copies of all appeal determinations issued by Albany County, for example, we would have had a very difficult time doing that. We would have had to dug through thousands and thousands of appeal determinations that we've received over the past, say, 3 years is our record retention period. We get between 4,000 and 5,000 appeals a year. We would have had to dig through all of that paper by paper to find the ones that were issued by Albany County. And the courts have held that we're not obligated to do that. On the other hand, if someone had come to us and said, I'd like a copy of an appeal determination that was issued January 15th, 2017 by Albany County, that's something we likely would have been able to do because now we had a date to focus on. Now, bringing us up to present, we do log them as we receive them. In addition, we get more and more appeals by email, which we love. If we have any agencies on that are listening in today and have not yet switched over to sending us their appeals via email, I'd encourage you to do so. Just save a tree, and it makes us happy. It makes record keeping and filing a little bit simpler. Certainly, you're welcome to continue to mail them to us. We're not going to turn you away. We'll keep accepting them, but email is perfectly fine and great with us. And as those emails come in, we just keep a database of the information of the agency, the person who made the appeal, the agency who issued the appeal determination, and the corresponding dates. So now if someone made a similar request, it would make it a lot easier for us to locate the responsive records. Time limits. When an agency receives a Freedom of Information Law request, it's obligated to respond in some manner within the first 5 business days. One option is to simply respond to the request and provide access to the record sought. Another option is to deny the record sought within that first 5 business days. Third option is to state we do not possess the record that you are seeking, or that we are unable to locate the record you are seeking after a diligent search. The fourth option becomes more common when you're either a larger agency that's dealing with a large volume of Freedom of Information Law requests, or even if you're a smaller agency, but this particular request is voluminous and complicated. And if that's the case, within those first 5 business days, an agency is going to be obligated to acknowledge receipt of the request within 5 business days. That acknowledgement letter should include an approximate date by which it plans to respond. In general, the expectation is that that date should not be more than 20 business days for most requests. However, the legislature understood that there may be situations where more than 20 business days from the date of the acknowledgement is warranted. And so what the law states is that you can take more than 20 business days, but if you're going to do so, you must provide a reason for the delay, and you must provide a date certain that is reasonable given the circumstances of the request. It's the opinion of the Committee on Open Government that agencies should not be engaging in issuing repeated extensions. For example, sending out letters month after month after month, stating that they need another 30 days, whatever the case may be. We do not believe that that is compliant with either the language or the spirit of the statute. However, because the legislative language, the statutory language, isn't quite as clear as we would like it to be, the courts have not interpreted the statutory language the same way the Committee on Open Government has. The courts are generally going to just look from a straight reasonableness standard and whether the agency has continued to keep the applicant updated regarding the status of the request and whether the amount of time it has taken has been reasonable. The other time frame that comes into play is if there is a denial of access issued by the agency, the applicant has 30 calendar days to appeal the denial. Once an agency receives an appeal, it has 10 business days to respond to the appeal. I think I mentioned earlier, agencies are required to accept requests via email, so their policy should include an email address. An agency cannot require a requester to use its own form, and this means electronic forms and portals that many agencies make available as a courtesy. And I am not in any way discouraging agencies from making these forms and portals available to the public. I think many people appreciate them and find them useful. But once an applicant puts a request in writing, that person has fulfilled their statutory obligation. If they put the request in writing and have directed it to the records access officer, no agency should ever be going back to that applicant and telling them that they need to fill out a form first. If the applicant emails the request or sends a letter, Again, they should not be being bounced back saying, please use our portal, please use this form. No, all they had to do was put it in writing and direct it to the records access officer. That's all they were required to do. And their FOIL request should not be delayed by forcing them to jump through additional hurdles that are not authorized by statute. Unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. So if a record would be publicly available to anyone who asked for it, things along the lines of contracts and fiscal information, a person should be able to send an email using something along the lines of janedoe@gmail.com, making a request for that publicly available document. The agency that receives that request, if they have it electronically, should be able to just attach it to the email, send it back to the person who made the request. On the other hand, if the records contain information which, if disclosed, would constitute an unwarranted invasion of personal privacy, and you want to find out if the person who's making the request is the subject of the records, an agency can ask that question. If the person refuses to answer the question, then you can assume that they are not the subject of the records, and the records can be redacted as appropriate, as going on the assumption that the person who's making the request is not the subject of the records. Appeals. There are two situations under the Freedom of Information Law that gives rise to the right to file an administrative appeal. The first is an express or an affirmative denial of access, and that's when a record is possessed by the agency, but is withheld in whole or in part. So a FOIL request is made to the agency identifies the record, locates it, reviews it, and determines either that it is subject to one of the permissible grounds for denial in its entirety, or that certain portions of the record should be redacted. If that's the case, a determination letter must be sent. A letter must be sent to the applicant providing a reason for the denial, a reason or reasons for the denial in writing, and advising the individual of their right to file an administrative appeal within 30 calendar days, and providing directions as to who the appeal should be directed. The second situation that gives rise to the right to file an administrative appeal is when there's a constructive denial of access. And that's when an agency fails to respond to the FOIL request within the time limit set forth in the statute. So if someone submits a FOIL request and the 5 business days comes and goes without a response, the applicant can treat that as a constructive denial of access. Or if it is acknowledged and the agency states we'll get back to you within 20 business days, but fails to do so, again, that's a constructive denial of access. Another situation that could be considered a constructive denial of access is when an agency acknowledges the request and states that they need more than 20 business days to respond to the request. They provide a date that they believe is reasonable, but perhaps the applicant disagrees. Maybe the agency says it's going to take us 6 months or a year to respond to your request, and the applicant just feels that that's just a really excessive amount of time to have to respond to this particular FOIL request. The applicant has the right to challenge that length of time. They have the right to treat it as a constructive denial of access based on their opinion. The amount of time, that the date certain by which the agency has advised that it plans to respond is unreasonable. So that's the position of the applicant, that the date is unreasonable. The agency has an obligation to respond to this request. They can either reduce the amount of time, they can provide the records right away, or the other option is that they can basically uphold that initial determination and state, no, we've done a careful evaluation of how long it's going to take us to respond to this FOIL request, and we still continue to believe that it's going to take 6 months to fully gather and review these records to determine rights of access. But the person does have a right to challenge that that constructive denial, that alleged constructive denial in terms of the last situation. We do have model language for both types of appeals on our website. If anyone is looking to file an administrative appeal, if you go to our homepage of our website, there is a link to model appeal language. So I have 2 slides here that contain most of the permissible grounds for denial. The ones that are not listed on my 2 slides here all relate to vehicle and traffic law and don't come up particularly often. They relate to things like red light cameras and things of that nature, but it's governed by vehicle and traffic law. So I've included in this slide and the next slide the grounds for denial that come up most frequently. And the theory is that these statutory grounds for denial is based on the idea that some type of harm would be caused by disclosure, whether it's harm to a particular individual, harm to a corporation, even harm to the agency. When I say harm, I don't mean embarrassment, I mean actual harm. So we'll talk about some of the more common grounds for denial. As I mentioned, they're on these 2 slides. All of them are on these 2 slides, except for the vehicle and traffic ones. These are all available on our website, in the statute, on my slides, in our publication entitled Your Right to Know. So don't feel like you need to take pictures or take notes. It's all available on our website. So the first ground for denial is when a record is exempt from FOIL disclosure by state or federal statute. And generally what this means is there's some other specific state or federal statute that governs disclosure of this type of record. And if there's a separate specific statute that governs disclosure of a particular type of record maintained by a government agency, that's the statute that is going to take precedence over FOIL. All agencies should be ensuring that they're complying with this separate specific state or federal statute. If they can comply with both FOIL and the separate statute, that's great, that's wonderful. But oftentimes there's going to be that state or federal statute that limits disclosure in some way. So we'll talk about some of those. One example is communications that are covered by the attorney-client privilege. New York State Civil Practice Law and Rules establishes and makes communications between an attorney and his or her client confidential, but only when the attorney is using the type of knowledge that they hopefully learned in law school to provide specialized legal advice. It has to be that communication really must be for the sole purpose of requesting and receiving legal advice. So for example, we're an office of attorneys here. If I email one of my colleagues just asking a more general question that does not involve the application of the statute, that's not going to be covered by the attorney-client privilege. However, if I'm consulting with my executive director seeking her legal advice prior to issuing an advisory opinion, that would be something that could be interagency, which we'll talk about, but also might be covered by the attorney-client privilege. Another example is there's the federal statute, the Family Educational Rights and Privacy Act, that makes student education records confidential. So this would apply to public schools, kindergarten through 12th grade. It applies to community colleges, SUNYs, CUNYs, any public institution of learning. FERPA applies to all educational institutions, but when you're dealing with both with a public learning institution, you have to balance FOIL and FERPA. And when you're dealing with student education records, FERPA is always going to come first. You always want to make sure that you're complying with FERPA before you start thinking about FOIL. Mental health records are made confidential by mental hygiene law. Autopsy records are confidential under New York State county law. Phone calls, recordings, transcripts, and other records of calls made to a county-operated E911 system are made confidential by county law. Social Security numbers are confidential pursuant to Public Officers Law 96A. So any record that contains an individual's Social Security number, that Social Security number should always be redacted prior to the record being disclosed. Some water. Another common ground for denial of access is when disclosure of a record or a portion of a record would constitute an unwarranted invasion of personal privacy. Personal privacy is often subjective. What one person might find objectionable, another person may not be bothered by it all. So oftentimes the courts are going to look to a reasonable person standard. The courts have weighed in on some issues, for example, employment applications of persons not hired. This is actually addressed in the statute. The statute states that the names and home addresses of individuals who apply for a position or who are applicants for employment does not need to be disclosed. In addition, the actual employment history or medical history of a person who has applied for a position. So we're not talking about current public employees. For example, there's a big difference between someone making a Freedom of Information Law request for my resume. I am a current public employee. If you make a Freedom of Information Law request for my resume or my job application, there's a lot of that information that's going to get disclosed. You can find out. I've been a public employee for going on, I think 22 years now. I've been a public employee. You can find out where I've worked from my first day of work until now. You can find out what positions I've held. You can find out my salary. There's a lot of information about public employees that you can obtain. However, if someone from the private sector, for example, applied for a position as a public employee or official and was not hired, there's going to be very limited information you're going to be able to find out. The person is entitled to privacy relating to their identity. If you are not able to redact a resume or an employee application sufficiently to protect that person's identity from being disclosed, then perhaps the entire document might be able to be withheld. Home telephone numbers and personal cell phone numbers of all members of the public, including public employees, can be withheld. Medical information, and I'm not talking about medical information maintained by a healthcare provider. Like, for example, going back to the mental health records, those are often those are maintained in some settings by county mental health departments and state-operated psychiatric centers. So in addition to mental hygiene law making those records confidential, you also have to think about the federal HIPAA privacy regulations. In addition, you have public hospitals that are operated by counties, by the state. And again, as a healthcare provider, they're required to maintain medical records in compliance with the federal privacy regulations. But let's say an employer comes into possession of medical information about one of their employees. Perhaps that person had to go through a workers' compensation claim, or perhaps they are out on family medical leave. Some example like that, information that's in their personnel file that reflects their medical condition. So it's not governed by HIPAA, it's not governed by public health law or mental hygiene law, but access to those records could be denied on the ground that disclosure would constitute an unwarranted invasion of personal privacy. The law specifically states that a public employee's home address does not need to be disclosed. Lists of names and addresses of natural persons, if that information would be used for solicitation and fundraising purposes. I'm going to spend just a second on this because I feel like in the past several months, I've seen a couple of situations where agencies are attempting to get applicants for records to sign a consent form stating that they will not use any record that they receive for solicitation or fundraising purposes. That's not appropriate. That's not permissible under the statute. The only time an agency can request a certification from the applicant that they will not use the information for solicitation or fundraising purposes is when the applicant is requesting lists of names and either home or mailing addresses or email addresses of natural persons. By natural persons, I mean, people like residents, you and me in our natural capacity, as opposed to our official, our employment capacity, our business capacity. If you're a small business owner, your address of your business can get disclosed. But when you go home at the end of the day, the address where you live should not. The agency is permitted to withhold that information. Mugshots that are maintained by law enforcement agencies can be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Law enforcement records. This is a two-part test, and the agency must be able to establish that the record meets both parts of the test. One is that the record has been compiled for law enforcement purposes. And based on judicial precedent, what the law means when they say compiled for law enforcement purposes, they're looking to what the records are being used for at the time the FOIL request is made. So it doesn't really matter so much what the records were used for when they were first created. It's what they're being used for now at the time the FOIL request was made. And the example that I'm going to use is based on the decision that I'm referencing here, is that there was a case that went to court in 2017 because the New York Times made a Freedom of Information law request to the New York State Executive Chamber for a former employee's time and attendance records. Now, most people would not consider time and attendance records that are compiled for law enforcement purposes. However, at the time that the FOIL request was made, this particular individual, this former employee of the Executive Chamber, was under investigation by the United States Department of Justice, and the United States Department of Justice had obtained copies, had required that the Executive Chamber provide it with copies of this former employee's time and attendance records. So at the time the FOIL request was made, the records had been compiled for law enforcement purposes. The courts have also held that this does not need to be simply for a criminal law enforcement purpose. The records can also be compiled for a civil law enforcement purpose. So that's part one of the test. The second part of the test is where disclosure would cause one of the harms envisioned by the statute. For example, would disclosure interfere with a law enforcement investigation or judicial proceeding? If the agency that receives the request is not the agency that is conducting the law enforcement investigation that the records relate to, and it is considering denying access, the agency that received the FOIL request needs to check with the agency that is conducting the investigation before making a determination. So, for example, if the request goes to the police department, but the police department has done their part and has passed it over to the district attorney's office, the police department needs to check with the district attorney's office and find out whether, in fact, disclosure would interfere with the investigation or judicial proceeding. The second example is where disclosure would deprive a person of a right to a fair trial or impartial adjudication. Would disclosure identify a confidential source or disclose confidential information relating to a criminal investigation, or would it reveal non-routine criminal investigative techniques or procedures, the types of things that might allow a potential lawbreaker to evade law enforcement detection? A third permissible ground for denial is when records constitute intra-agency material or interagency material. So intra being all within a single agency, and inter meaning between or among two or more agencies, as the term is defined by FOIL. And the purpose of this exemption is to protect the government agency or agency's deliberative process. So anytime these types of communications or these records reflect opinions, recommendations, advice, impressions, subjective things, again, things that reflect the deliberative process, those records can be withheld. This might be a draft document, it might be emails, it might be a memo, but if it hasn't been finalized, if it's not a document that's been finalized and it contains advice, opinions, recommendations, the deliberative aspect of the government's decision-making process, it can be withheld as long as it's maintained within a single agency or two or more state government agencies. So even when I use that term state government agency, if someone from a village emails me at the New York State Department of State, that's still interagency material because they're a government agency as defined by FOIL and I'm a government agency as defined by FOIL. So if someone emails me and asks my opinion about something, about whether a record needs to be disclosed under FOIL, and I respond with my opinion, those email communications represent interagency material that could be withheld if a FOIL request was received by either of our agencies. There are exceptions to this rule. If those intra or interagency materials contain statistical or factual tabulations or data, it must be disclosed. The courts have interpreted this pretty broadly to mean any objective information. Instructions to staff that affect the public must be disclosed. Final agency policies or determinations must be disclosed. And external audits, including audits conducted by the Office of the State Comptroller, must be disclosed. There are two provisions. There's a single provision in the Freedom of Information Law that permits a person who is seeking records to request a certification under two different circumstances. The law states that upon payment of or offer to pay a fee, the entity, meaning the agency, shall provide a copy of the record and certify to the correctness of the copy if so requested, or shall certify that it does not have possession of the record and that that record cannot be found after a diligent search. So the first situation is when a Freedom of Information Law request is made to an agency. The agency obtains the record, gathers the record, locates the record, makes a copy of the record, provides the copy to the applicant, and the applicant wants a certification that the copy that they received looks exactly like the original that's maintained with the government agency. That's what this certification means. It's not requiring that the agency certify that the content of the record is accurate, just that the copy looks exactly like the original. The second scenario comes up much more frequently, and that's when an agency responds to a FOIL request by stating that it does not possess the record that was being sought, or that the record could not be located after a diligent search. This is not a denial of access. If an agency states that it does not possess the record sought or the record could not be found after a diligent search, it's just not a denial of access. An agency cannot provide what it does not possess. But what it does give rise to is the right on the part of the applicant to request a certification that the record either is not within the agency's possession or that it cannot be found after a diligent search. The courts have held that this certification does not need to be in any particular form. My recommendation is just to model the language of the statute. For example, I would say, I, Kristen O'Neill, on behalf of the Committee on Open Government, certify that that the committee does not possess, and then I would probably provide a brief description of the requested records. This can be by email, can be by letter. Again, there's no particular format that it needs to follow, but my recommendation is to use the words "I certify," because that's what it is. It's a certification. Right to appeal. When an applicant is denied access to a record or any portion of a record, that means if there's a single redaction on a piece of paper, on a record, it is a denial of access. The applicant has 30 calendar days to appeal that denial. The FOIL appeals officer by statute is the head or governing body of an agency or the person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same person as the records access officer. Within 10 business days, the FOIL appeals officer must either provide the records sought or fully explain the reasons for further denial, and sometimes it's a combination of both those things. The law does not contemplate a remand back to the records access officer. It is the responsibility of the appeals officer to review those records at the appeal level. Just as a reminder, agency is required to send a copy of the appeal and the appeal determination to our office. Fees. It's funny, I've been saying for ages that there are two fee structures under FOIL. And I got called on it the other day when I was doing a live presentation, and I'll explain to you why I was called on it. But I'll start out by saying I still, to some extent, think there's only two fee structures under FOIL. But what the law states is you can only permitted to charge the fees as authorized by the statute unless some other statute allows that agency to charge a different fee. So the person who called me out was telling me that, well, you're not taking into consideration those situations where a separate statute authorizes a different fee. And I agreed with him. I said, you're absolutely right. So now I'm going to try to remember to bring that up in my presentations. So there are the two fee structures established by FOIL, but agencies should also take into consideration, and the person who's making the request has to take into consideration that there might be some other statute that authorizes that agency to charge a different fee. For example, county clerks are allowed to charge 65 cents per page for records that it maintains as a county clerk. There's a provision of law that lets them do it. The New York State Police are permitted to charge, I believe it's $15 per incident report. They're allowed, it's a fee that the statute allows them to charge. But it's not set forth in the Freedom of Information law. It's set forth in a separate statute that specifically applies to them. So those are just a couple of examples. But the FOIL fee structures, please keep in mind they cannot be combined. The first is for photocopies of paper records up to 9 by 14 inches. If you are if you are the agency making photocopies for somebody for pieces of paper up to 9 by 14 inches, you are allowed to charge 25 cents per photocopy, and that's it. That is the only fee you are allowed to charge for making copies. Agency is not permitted to charge for the time it takes to locate the records. They're not allowed to charge for administrative costs. They're not allowed to charge for the time it takes someone to review those records to determine rights of access. Only fee that can be charged is 25 cents per photocopy up to 9 by 14 inches. End of story, done. The second fee structure allows an agency to charge the actual cost of reproduction for all other records, meaning any record that is either larger than 9 by 14 inches, like maps and blueprints, or records in some other format, like data extracts, scanning, audio, video, those types of things. When you're not dealing with paper, then the law states you can charge the actual cost of reproduction. And then the law specifies what you are specifically allowed to take into consideration when determining the actual cost of reproduction. And the rule that comes up for discussion most often and causes the most confusion is the 2-hour rule. So what this fee provision allows is when you're making copies of a record other than photocopies, you are allowed to charge the salary of the lowest paid employee capable of preparing the copy of the record, but only if it takes at least 2 hours to make the copy. Again, you cannot charge for the search time. You cannot charge for the time it takes to locate the records. You cannot charge for administrative costs. You cannot charge for the time it takes to review the records to determine rights of access. That 2-hour rule only applies to the actual time it takes to make the copy. If someone is standing at a multifunction copy scanner machine and it takes them at least 2 hours to scan all of the records, that's when you can charge. If you have somebody that needs to sit down at a computer and it takes them at least 2 hours to extract the data into a report, that's when you can charge. You are not permitted to charge anything for the time it takes to review those records, to gather those records. The law also allows you to get reimbursed for the actual cost of an electronic storage device, like a zip drive or a CD. If you do not have the technological capability of making a copy in-house and you need to send it out to a third-party vendor, whatever the third-party vendor charges you, you can pass that cost along to the applicant. The law requires agencies to notify the applicant in advance of any fees under fee structure number 2 that it is going to incur. So, for example, if you can approximate that it's going to take someone who makes $20 an hour 3 hours to prepare the copy, you need to let the person who made the request know about the $60 fee before you incur the cost. You need to be sure that they're willing to pay that fee. You need to let them know it's going to cost $60. Make sure they're willing to pay it before you incur the cost. Same thing goes with third-party vendor. You reach out to Staples, say how much is it going to cost to make copies of these blueprints. You find out what that cost is going to be. You need to let the applicant know in advance. You can also require that they at least put a deposit down or pay the full amount in advance before you as a municipality incur the cost. So again, especially if it's going out to a third-party vendor, you don't want to be out that money. So if they're going to charge you $100 to make any particular copy, you go to the person, say it's going to cost us $100. Please send us a check for $100 before we send it out to the third-party vendor. Oh, what was I going to say? I just had thought that went in and out of my head very quickly. Oh, while it's not required by statute, I always think it's a good idea to let people know in advance of any fee that's going to be charged. It's not required for photocopies, but if it's a particularly large copying job, my recommendation is to let the person know in advance before you incur the cost as an agency. You don't want to waste, kill the trees and waste hundreds or thousands of pieces of paper and the ink in the photocopy machine only to find out that the person who made the request just can't afford to pay for those copies or was not expecting the response to be so voluminous and just is not willing to pay it. So while it's not required by statute for fee structure number 1, I do recommend it. There's a new provision of the statute that, to be quite honest, is based on practicality and common sense. If an agency prepares an electronic copy of a record in response to a FOIL request, and within the following 6 months, a request for the same exact record is made, the agency is not permitted to charge that second requester the fee for making the copy. And here's why, is that there's a 6-month record retention requirement for all government agencies for records relating to a FOIL request. So once you prepare that record for the first request, you are obligated under the New York State Record Retention and Disposition Schedule to maintain that electronic copy of that record for a minimum of 6 months. So if someone makes a request for that same exact record within that 6-month period, there should be no reason why you would need to incur the cost of making a new copy. So to wrap things up here, the Committee on Open Government does not have enforcement authority. I always like to point that out because we do get a lot of times where people are contacting us, asking us to either investigate complaints or to try to compel an agency or a public body to take certain action. We do not have that authority. We provide advice and legal opinions regarding the open government statutes. We do not have investigatory or enforcement authority. Enforcement of both the FOIL and the open meetings law is through a civil practice law and rules Article 78 proceeding in state Supreme Court. A prevailing party in an Article 78 proceeding, Article 78 FOIL proceeding, can be awarded attorney's fees and other reasonable litigation costs. Those fees are mandatory on the part of the judge when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. It is discretionary on the part of the judge when the requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time frame. So finally, I just want to remind everyone, as usual, that anyone is welcome to contact our office by phone or by email with questions, whether you're a government employee, member of the public, media representative, all are welcome to contact our office with your questions. You can call us, you can email us. We are happy to help. I'm going to stop sharing my PowerPoint and I'm going to go into the chat feature to see if anyone has any questions. And if you don't have a chance, if you don't really have time to formulate a question right in this moment, you are welcome to obviously email me later. If you do use the Coug account and you want to just write attention Kristen on it so that I know that it's a follow-up to this presentation, I'll just give it a minute or so. So we're coming up maybe on, there might be, usually I almost guarantee that we're in the process of preparing our annual report to the governor and the legislature. It's due by December 15th of this year. And I know as we start drafting, by the time, at some point before we submit that report to the governor and the legislature, there's going to be some change to either the Freedom of Information Law or the Open Meetings Law. It's inevitable. But as I said, we always try to keep that information up to date. We put out posts up on our website and let people know. If people are interested in the recommendations that the Committee on Open Government are making to the governor and the legislature this year, the deadline is December 15th. At some point, hopefully right then or very shortly thereafter, it will get posted on our website. And I hope everybody has a lovely day and a lovely fall. And if you have any questions, you know where to find me. Have a great day. Thank you.